हाय फ्रेंड्स। इनकम टैक्स के मैटर में अगर आपने सुप्रीम कोर्ट के रीसेंट रूलिंग के ट्रेंड को ऑब्जर्व किया होगा तो आपको पता होगा कि सुप्रीम कोर्ट ने काफ़ी सारे जजमेंट को रेवेन्यू के फेवर में देके एसएससी के अगेंस्ट में दिया है। बट कॉन्ट्ररी टू दैट ट्रेंड, सुप्रीम कोर्ट ने रिसेंटली 10 अप्रैल को एक बहुत ही बेहतरीन जजमेंट एसएससी के फेवर में दिया है इन केस ऑफ टीडीएस पेनल्टी। सुप्रीम कोर्ट ने इस जजमेंट के द्वारा एक बहुत ही फंडामेंटल प्रिंसिपल है जो कि है for failure to deduct TDS and for late deposit of TDS, वो दोनों जो प्रिंसिपल है उसको डिफ्रेंशिएट किया है। आज इस वीडियो में हम उसी जजमेंट के बारे में बात करते हैं। केस में जाने से पहले हम जो प्रोविजन है सेक्शन 271 कैपिटल सी उसको देख लेते हैं, उससे ये रूलिंग को समझने में हमें मदद मिलेगी। सो व्हाट इज 271C? Penalty for failure to deduct TDS. Any person fails to deduct the whole or any part of the tax as required by or under provision of the chapter of TDS, or pay the whole or any part of the tax as required by or under subsection 2 of section 1150 or proviso to section 194B, then such person shall be liable to pay by way of penalty a sum equal to the amount of tax which such person failed to deduct or pay as aforesaid. Any penalty imposable under subsection 1 shall be imposed by the Joint Commissioner. यानी अगर आपने यू आर पर्सन लायबल टू डिडक्ट टीडीएस, अगर आप डिडक्टर है और आपको अगर किसी का टीडीएस काटना हो और आपने नहीं काटा है तो इस सेक्शन में आपको जो अमाउंट इक्विवेलेंट टू टीडीएस है उसके अकॉर्डिंग आपको उसकी अमाउंट की पेनल्टी आपको लग सकती है, और ये पेनल्टी आपको इम्पोज होगी जेसी द्वारा। और यहाँ देखिए ये वर्ड है सच पर्सन शैल बी है, मतलब ये पेनल्टी वेव नहीं हो सकती है अगर आपने फेलियर किया है, अगर आपने टीडीएस नहीं काटा है तो ये पेनल्टी मैंडेटरी है, लेवी होगी ही। ये बेसिक प्रेमाइस है, ये सेक्शन है। अब हम रूलिंग में जाते हैं कि ये केस क्या था सुप्रीम कोर्ट के आगे। द केस बिफोर सुप्रीम कोर्ट वाज Messrs US Technologies International Private Limited वर्सेस कमीशन ऑफ इनकम टैक्स। ये जो पैरा है हाईलाइट किया गया है, विच इज द क्रक्स ऑफ द होल जजमेंट। Section 271C 1A shall be applicable in case of the failure on part of the concerned person SSC to deduct the whole or any part of the tax as required by or under provision of the chapter TDS. The word used in the section 271C 1A are very clear and relevant words used are fails to deduct. It does not speak about belated remittance of the TDS. At this stage, it is required to be noted wherever the Parliament wanted to have the consequences of the non-payment and or belated remittance of the TDS, the Parliament legislature has provided the same, like in section 201(1)(a) and 276(b. यहाँ यानी सुप्रीम कोर्ट का कहना है कि जो फेलियर टू डिडक्ट है और जो बिलेटेड रेमिटेंस है दोनों इक्विवेलेंट नहीं है, मैंने काटा ही नहीं है, वो केस कवर होता है 271C में। बट इस केस में एसएससी ने काटा है बट लेट पेमेंट किया है, लेट डिपॉजिट किया है, उसके लिए ऑलरेडी इंटरेस्ट की प्रोविजन है, उसमें पेनल्टी आप ले भी नहीं कर सकते। यहाँ आप देखिए 271C में कहीं लेट डिपोजिशन नहीं है, फेल्स टू डिडक्ट है, या अगर आपने पेमेंट किया ही नहीं है, लेट पेमेंट का कोई जिक्र नहीं है 271C में। सो दैट इज व्हाट सुप्रीम कोर्ट वांटेड टू कन्वे। As observed herein, fails to pay the whole or any part of the tax would be falling under 271B, and the word used between 271(1)(a) and B is or. At this stage, it required to be noted that 271B provides for the prosecution in case of failure to pay to tax to the credit of the central government. The pay is missing in section 271C(1)(a). Now, so far as reliance placed on the CBDT circular 551 dated 21st 3rd January 1998 by learned ASG is concerned. At the outset, it is required to be noted that the said circular as such favors the SSE. Even the CBDT has taken note of the fact that no penalties envisaged under Section 271C of the Income Tax Act for the non-deduction of TDS and no penalties envisaged under Section 271C for the belated remittance payment deposit of the TDS. Even otherwise, the word fails to deduct occurring in 271C cannot be read into failure to deposit, paid to deduct, decided in favor of the SSE. So this was also delivered by Justice Amar Shah, who is not so favorite of the SSE. Let's look at the facts of the case. The facts leading to the present appeals in nutshell are as under. By order dated so and so, the AACIT by way of order under section 271C levied penalty equivalent to the amount of TDS deducted for the AY 10/11 to 12/13 on the ground that there was no good reason and sufficient reason for not levying penalty. The CIT appeal dismissed the SSC's appeals by common order dated so and so. The ITAT allowed the SSC's appeals by holding that the imposition of penalty under section 271C was unjustified and reasonable causes were established by the SSC for the remitting TDS belatedly. यानी यहाँ एसएससी ने टीडीएस बिलेटेड डिपॉजिट किया था, नन डिडक्शन नहीं था या नन पेमेंट भी नहीं था. By impugned common judgment and order of the High Court has allowed the revenues appeal relying upon its earlier judgment. The impugned judgment and the order passed by the High Court is the subject matter of the present appeal. We'll dialectically see what court has said. The short question which is posed for the consideration of this court is, in case of belated remittance of the TDS after deducting the TDS, whether such SSC is liable to pay penalty under section 271C of the Income Tax Act 1961. The question which also posed for the consideration of this court is, what is the meaning and scope of the word fails to deduct occurring in section 271CA and whether an SSE caused delay in remittance of the TDS deducted by him can be said to person who fails to deduct TDS. In order to appreciate the rival contentions and answer the opposite question, it is necessary to have any analysis of the statutory provision. Then court reproduce section 201, which we already have gone through, 271C, (273B), 276B, which is imprisonment. Now we'll see. At the outset, it is required to be noted that all these cases are with respect to belated remittance of the TDS, though deducted by the SSE, and therefore 271CA shall be applicable. At the cost of repetition, it is observed that it is a case of belated remittance of the TDS, though deducted by the SSE, and not a case of non-deduction of TDS at all. As per section 271CA, if any person fails to deduct the whole or any part of the tax as required by or under any provision of chapter, then such person shall be liable to pay by way of penalty a sum equal to amount of tax which such person shall fail to deduct or pay as aforesaid. So far as failure to pay the whole or any part of the tax is concerned, the same would be with respect to section 271(1)(b), which is not the case here. Therefore, 271(1)(c)(a) shall be applicable in case of failure on part of the concerned person to deduct the whole or any part of the tax as required by or under provision of chapter TDS. The word used in the section 271(1)(a) are very clear and relevant word used are fails to deduct. It does not speak about belated remittance of the TDS. As per settled position of law, the penal provisions are required to be construed strictly and liberally. Literally. As per the cardinal principle of interpretation of statute and more particularly the penal provisions are required to be read as they are. Nothing is to be added and nothing is to be taken out of the penal provision. जो penal provision होती है उसको strictly interpret करना चाहिए. Therefore, on the plain reading of the section 271C, there shall not be penalty leviable on the belated remittance of TDS after same is deducted by the assessee. Section 271C of the Income Tax Act is quite categoric. Its scope and extent is discernible from the provision itself, unambiguous terms. When the non-deduction of the whole or any part of the tax as required by or under the various instances or provision of the TDS would invite penalty, only a limited tax involving subsection 2 of section 115O or covered by second proviso to 194B alone would constitute an instance where penalty can be imposed in terms of 271C1B, namely on non-payment. It is not for the court to read something more into it, contrary to intent and legislative wisdom. So here in this para, court was very clear कि जो नॉन डिडक्शन के केस है होल और पार्ट में अगर किसी डिडक्टर ने टीडीएस डिडक्ट ही नहीं किया है या फिर पार्टली डिडक्ट किया है तो वही केस 271C1A के केस में जो फिट होंगे. जो नॉन पेमेंट के केस में उसमें सिर्फ जो 115O है या फिर 194B के जो केस है वही फिट होंगे. तो जो 1A है और 1B है वो दोनों डिस्टिंक्ट है, वो दोनों का आप इंटरचेंज नहीं कर सकते, उसको स्ट्रिक्टली रीड करना चाहिए. और जो नॉन पेमेंट लेट पेमेंट है उसको 1A में आप इंक्लूड नहीं कर सकते. फिर यहाँ कोर्ट जो लेट पेमेंट है, जब हम टीडीएस लेट डिपॉजिट करते हैं तो आपको पता है कि 201 में इंटरेस्ट लगता है, उसकी बात कर रही है. एट दिस स्टेज इट इज रिक्वायर्ड टू बी नोटेड दैट wherever Parliament wanted to have consequences of non-payment and or belated remittance of the TDS, the Parliament legislature had provided the same like in 201(1)(a) and section 271(6)(b. Section 201 provides that in case of tax has been deducted at source but same is subsequently remitted, may be belatedly or after some date, such person liable to pay interest as provided under 201(1)(a). The levy of interest under 201(1)(a) thus can be said to be compensatory in nature and belated remittance of the TDS after deducting the same. Therefore, consequences of the non-payment belated remittance are specifically provided. Section 201(1)(a). Similarly, section 271(6)(b) talks about the prosecution on failure to pay the TDS after deducting the same. At this stage, it is required to be noted that 271C has been amended subsequently in the year 97, providing that A and B, as observed here above, fails to pay all whole or any part tax would falling under 271B, and the word used 271A and B is or. At this stage, it is required to be noted that 276B provides for the prosecution in case of failure to pay tax to the credit of the central government. The word pay is missing in 271C1A. Now, so far as the reliance placed by the CBDT circular dated by the learned ASG is concerned, at the outset, it is required to be noted that the said circular as such favors SSC. Paragraph 16.5 of the circular reads as follows. insertion of the new section 271C to provide for the levy of penalty for failure to deduct TDS under old provision of the chapter of income tax. No penalty was provided for failure to deduct TDS. This default, however, attracted prosecution under provision of section 276B, which prescribed punishment for failure to deduct TDS or after deducting failure to pay the same to the government. It was decided that first part of the default, that is failure to deduct TDS, should be made liable to levy penalty, while the second part of the default is failure to pay TDS, government, which is more serious offense, should be continued to attract prosecution. यानी अगर आपने टैक्स काटा है और काट के डिपॉजिट नहीं किया है तो पेनल्टी लगेगी, अगर आप तो प्रोसिक्यूशन लगेगा, अगर आपने काटा ही नहीं है तो पेनल्टी 271C में लग सकती है. द अमेंडिंग एक्ट 1987 हैज अकॉर्डिंगली इंसर्टेड to provide for the imposition of penalty on any person fails to deduct at source as required under provision of chapter. The penalty is the sum of equivalent of the TDS. Unfair reading of the CBDT circular, it talks about the levy of penalty on failure to deduct TDS. It also takes note of the fact that if there is any delay in remitting the tax, as it will also take note of, it will attract payment of interest under section 201(1)(a) of the act, and because of the gravity of the mischief involved, it may involve prosecution proceeding as well under 276B. If there is any omission to deduct the tax at source, it may lead to the loss of revenue, and hence remedial measures have been provided by incorporating the provision of ensure that tax liability to the said extent would stand shifted to the shoulder on the party who failed to effect deduction in form of the penalty. On deduction of the tax, if there is any delay in remitting the amount, it has also been satisfied by the interest under 201, besides the liability to face prosecution of proceedings if launched. Even CBDT has taken note the fact that no penalty is envisaged under 271C for non-deduction of TDS and no penalty for belated remittance. Even otherwise, the words, this is very important, fails to deduct occurring in 271C cannot be read into failure to deposit. Therefore, on true interpretation of 271C, there shall not be any penalty under 271C on mere delay in remittance of the TDS after deducting the same by concerned assessee. As observed herein above, the consequences on non-payment belated remittance would be liable under interest 201A and 276B. In view of the above, respective assessees remitted the TDS though belatedly, and it is not the case of the non-deduction of TDS at all. Therefore, any question of applicability of 273B of the no penalty of 271C is liable. In view of the above and for the reasons stated above, all these appeals succeeded. Impugned judgments ordered passed by the High Court are hereby quashed and set aside. For the interpretation of 271C of the Income Tax Act is answered in favor of the assessee and against the revenue. And it is specifically observed that and held that on mere belated remitting the TDS after deducting the same may be concerned person, no penalty shall be levied under 271C of the Income Tax Act. Present appeals are accordingly allowed. सो फ्रेंड्स, वैसे भी TDS में बहुत सारी लिटिगेशन चल रही है. इस केस के द्वारा सुप्रीम कोर्ट ने एक एक्सीलेंट क्लैरिटी दी है कि कौन कौन सी कॉन्सिक्वेंसेस में कौन कौन सी पेनल्टी लग सकती है. व्हाट आर द कॉन्सिक्वेंसेस फॉर फेलियर टू डिडक्ट, व्हाट आर द कॉन्सिक्वेंसेस फॉर फेलियर टू लेट डिपॉजिट, प्रोसिक्यूशन कब इन्वोक हो सकती है, इंटरेस्ट कब लग सकता है. सो इसमें एसएससी को अच्छी रिलीफ मिलने वाली है. We are hoping more such judgment from the Supreme Court in near future. So I hope ये वीडियो आपको पसंद आई होगी. Have a good day.